My name is Michael, and I am a writing, reading, speech coach in the Learning Commons of the College of DuPage. This is part 2 of the Legal Writing web series. If you skipped part 1, I'm going to give you a little bit of background before we start. I am an inactive California attorney. This means I am actually licensed in the state of California to practice law, but because I am not currently living in California, I am inactive, which means I don't actually practice. When I was working as an attorney, I was in civil litigation and workers' compensation litigation. I wrote all the time, whether it was letters, motions, responses, discovery, internal memorandum, you name it, I was writing it, just like every other new paralegal or new attorney out there. As you write, you will note that there are 3 main types of legal writing. There are the case brief, the legal brief, and correspondence. Each of the following sessions will cover each one of those in turn. This particular session is about the case brief. Case briefs are generally only seen in an academic setting. Once I started practicing, I never wrote a formal case brief. But, and this is the key part, the concept behind knowing how to do a case brief is important to a practicing attorney or paralegal. And anytime I read a case, I annotated it like I was going to write a case brief. I would highlight what was important, what were the significant facts, and what was the holding. And of course, the case likes to tell you what the issue is. So in many ways, the case brief, while you never write one in practice, is the concepts behind it are very important. So here's just a brief overview of what goes into a case brief. Now, as I alluded to in the last section, this is the most common type of writing that you'll do while you are training to be a paralegal or attorney. It is useful to get to the essence of the case. Every case that you read in your classes has a point. There is a rule of law to learn and sometimes 2 rules of law. No casebook editor is going to pick a case for its flowery language. The job of the case brief is to condense those 5 pages or more pages down to a few paragraphs or even just a few sentences. This carries into the real world because it helps you learn how to read a case to support your argument. Generally, there are 4 elements in a case brief. There's case facts, an issue, a holding, and the reasoning. These are just general elements. If you have to submit a case brief as an assignment, you should absolutely follow your professor's requirements. They might require different items within the case facts. They might want to have a different section, but these are just the general rules. So let's take a closer look at the facts. Your case facts should include legally significant facts. They should consist of about 5 to 7 sentences. The procedural posture for the case, and the case facts section should not have any legal conclusions. Let's take a look at each of these a little bit more closely. What is legally significant depends on the case. In one case, it is totally irrelevant that an injury occurred on October 31st, 2015. However, if the injury occurred on October 31st, 2015, and the lawsuit is not filed until November 1st, 2017, you are almost certainly going to be time barred by the statute of limitations. In Illinois, as with most other jurisdictions in the United States, you only have 2 years to file a personal injury claim. If the accident occurred at 11:59 p.m. on Halloween night and the injuries were not discovered until after midnight, you might, and I stress might, have a case. Your client almost certainly would have a very good malpractice case against you if the judge deemed the initial lawsuit not timely. So you must be absolutely careful about what facts are important to what issue. Other legally significant facts truly depend on the type of case. Remember the essential elements to a tort case: duty, breach, causation, damages. Look for the facts that fit those patterns, that fit those elements. A criminal case is going to be dependent upon the statute. For example, burglary is a nighttime crime. It is most states you cannot commit burglary during the day. Procedural posture is where the case is in the legal system. Most class readings are opinions of at least the appellate court. Very rarely will a class reading be a trial court opinion. In your case facts, you should discuss what happened at the trial court. If we're at a higher court, what happened the first time in the appellate court? Sometimes a case will bounce up and down a few times, and you might be reading opinions that are written 3 or 4 years apart, but it's all the same case. Keep in mind that sometimes a state criminal case can go to the Supreme Court of the United States if a constitutional question is involved. So the idea behind the case facts section is to help you in course discussion, in the in-class discussion. For example, when you're on the hot seat, it's really good to have a brief summary of the case right before your eyes so you don't have to dig through the opinion to find the answer to your professor's questions. Don't get discouraged if you have a bad day on the hot seat. It is almost certain you will miss a legally significant fact. You are still in training. It is better to miss it now than rather on the final or during the bar exam or when you are actually practicing. Now, let's move on to issue statements. So, the issue is the main legal question before the court. Usually, it is explicitly stated within the opinion. It could be in a heading, it could be in a sentence that says the issue before the court is blank. Most cases on appeal actually have multiple issues to decide. But when we read for class, the editors of the casebook have edited the readings down to 1 or 2 specific issues. As you write your issue statement for class, you should keep in mind that generally you are going to follow the pattern under, does, when. This means under the law at issue, does this outcome result when these specific facts occur? Alternatively, you might hear the phrase whether plus facts plus law. Both of these will provide you with an equally good issue statement that you can use to argue what the issue is about the case. Some professors prefer one style, some professors prefer another style. You, as the student, if you're not given a mandate to follow one or the other, might prefer one or the other. So here are some examples of issue statements from cases that I've just completely made up for the most part. Under the probate code, is a will valid when it is witnessed by only one witness? Now, for that particular issue, we would need to look not only at the case, but the case probably would explore the probate code for that particular state, because that probate code would almost certainly tell us whether or not a will can be witnessed by one witness. And it might have other requirements if there's only one witness. For example, it might require a disinterested witness, which is someone who takes nothing under that particular will. I would say, based off of my experience, that the answer to that issue question would be probably not. That means the will is probably not valid. Okay, another example of an issue statement is, under Illinois law, is a driver negligent when she was blinded by sun glare and could not see the traffic light was red? For this particular answer, you would need to research a lot of motor vehicle cases. And when you're reading a court opinion, they most likely have already done so. So a few things to note here. It says under Illinois law, so we know we are only going to look at Illinois cases primarily. We're going to look for specific facts, and we're going to look for patterns within the prior cases. The answer, based on my experience to this question, is probably that driver is negligent even though they were blinded by the sun glare. Okay, the next issue statement I'm providing for you is as follows. Whether an officer using a heat-sensing gun on a suspected marijuana grower's home requires a warrant pursuant to the Fourth Amendment. Now that is an example of whether plus facts plus law. We're looking under the Fourth Amendment, where we have what the facts are and how those facts apply to that law. The next element of a case brief is the holding. This is the answer to the legal question posed under the issue. It might be explicitly stated in the opinion. For example, you might find a sentence that says, "We therefore hold," or "this court finds," or "I conclude that," and then the answer would follow. That is the holding. Sometimes it's not so obvious and it's buried in the tail end of the analysis. It might be a sentence, or it might only be a half a sentence to determine the answer to the legal issue. Sometimes, depending on the judge writing the opinion, it has its own section. The best thing you can do is to look at what you think the holding is and compare that to what you thought the legal question was, or the issue. Does the holding answer the issue question? When preparing your case brief, your holding should answer that question exactly. So, here are some examples of a possible holding statement. You'll notice the pattern here is that there is a yes or no answer plus a restatement of the legal question. First example, yes, a driver is negligent when running a red light while blinded by sun glare. You'll see that it follows very closely to the issue that was presented on the last slide. The other example is yes, an officer using a thermal gun on a suspected marijuana grower's home requires a warrant. That case was actually a Supreme Court case that was originated out of the state of Michigan, and it went all the way up to the Supreme Court of the United States because it did involve a constitutional question, as I stated earlier. Both of these issue statements that are before you are missing something. Both of them, I've neglected to include the law at play. So that is something you want to make sure your holding shows, what the law is. So that first one should state somewhere Illinois, right? It should say Illinois law because that's what we said the issue was. And that second one needs to state the Fourth Amendment so that it's clear that this is a constitutional question. The next element I wanted to cover for a case brief was the rationale. The rationale is the reason for the answer that the court provided in the holding. This is going to be the law, the fact application, and the court's decision. It's the reason for everything. It's the reason why this case is on appeal. It's the reason why, if we're in the Supreme Court, the highest court of the jurisdiction, it's the reason why it got appealed out of the appellate court. And the rationale is really the meat and potatoes of what the case stands for. It's going to tell us why that proposition exists, why the case means what it means. A good rationale should go through the history of the law, of how they came to their decision. So, what does this mean for you in your case brief? Your rationale should be a summary of what the court wanted. Some professors may ask you to include the particular case names that the court included in their rationale section. Some professors may ask you just to give us the legal explanation without citing to all the particular cases that a court cited to. The other thing to keep in mind is that the rationale is going to be affected by the type of opinion. And there are three main types of opinion. There's the majority opinion, which is the rule of law we need to follow. That is the current law, at least of the time that the opinion was written. There's the concurrence, which has the same answer, the same holding as the majority opinion, but it might have a different rationale. It might have a different reason. The dissent is generally something that disagrees with the holding of the majority. A lot of times they might look at the same cases, the same thought process, but they come to a different holding or a different answer. Now, the reason why a dissent is important is because it could help set up future attorneys to do another appeal in a different case with different facts that would maybe carve out whatever the majority had ruled on this particular case. It's basically a dissent is a future record, and it's going to be guidance for future attorneys if they ever come across similar facts but want a different outcome. That's what the dissent is for. That's why we do what we do in this job. Okay. Okay, so just to review, there are four main parts of the case brief. And again, these are general. If you are turning these in for an assignment, you might have different requirements. You might have different section headings. Please follow whatever your instructor is asking you to do. If you're doing this because you need this for your own personal notes, you can follow this pattern, or you can follow any other millions of patterns you might be able to find on the web. So there are four main parts, as I've discussed here. There's the facts, which are going to be legally significant facts. There's the issue, which is a single sentence. You're boiling down the main issue of the case down to one sentence. There's the holding, which is the answer to the issue question. That is also going to be a single sentence. Finally, you have your rationale, which is the explanation of everything, and that might be a couple of sentences. You're probably going to have to think a little bit on how a court got from one end of their rationale to the other end and how they got to their holding. But you should be able to parse it out. Just a few final tips here. If you are spending an hour copying your facts down, you probably need to change your focus. If you've already read the case and you understand enough of the case where you're at the point where you feel comfortable to write a case brief, but you still spend an hour writing out facts, you're doing something. You've missed something. You don't need to spend an hour copying the facts out. It also might be helpful as you're reading to have a group of highlighters or pens or something of different colors, so that way you can outline or highlight certain sections of the case with different colors. For example, you might use red for facts, blue for the issue, yellow for the holding, green for the rationale, or some other sort of notation device. I always would annotate the onto the side of the page in my casebook what the facts were. I would put a star by what I thought were the legally significant facts. I would use a different color pen to write, oh, here's issue or a holding, and then I would usually bracket off the main part of the rationale, which got me to the final answer from the court. So this covers all the information about case briefs that we're going to include here. If you have any questions or you want further explanation on what we've discussed, please feel free to make an appointment in the Learning Commons of the College of DuPage. Our information is on the screen, and we look forward to hearing from you. Please stay tuned for part 3 of the legal writing seminar. Thank you.